I would have to tackle what I consider to be two of the tougher problems we confront with the new economic theory, and that is to better understand the political and legal foundations of neoliberalism, the new normal for the global economy. The foundations of the issue of neoliberalism and the problem that triggered its global salience was the consequence of the defeat of Nazi Germany after World War II and the extension of the influence of the Soviet Union in Eastern Europe. And there the Stalinist regime imposed a form of state socialism. It extinguished private property, and the state claimed to have a monopoly on the means of production. This triggered a short conference in Montpellier, Switzerland, from a number of Western intellectuals, and they looked at the emergence of the Stalinistic state and the extinction of private property as one of the greatest threats to human freedom. In fact, they specifically maintained that the extinction of private property was the most egregious extinction of human freedom that they could imagine. So that's where the initial battle lines were drawn about the role of the state, the omnipotent role of the state, and the idea of the reassertion of the private sector as an important instrument for the maintenance of human freedom. That's, of course, a political and a legal implication as well. The next phase of this emerges in the early 1960s when a huge number of states were essentially decolonized. The UN recognized decolonization as an important progressive movement, but the problem with decolonization was that the economies of these decolonized countries, while they were politically free, they were economically still under the control of the former colonial powers. They called this neocolonialism. And that got the UN into looking at the idea of a new international economic order. And that is reflected in a number of instruments produced by the UN. The most important of which I will mention initially is that there were two resolutions dealing with the idea of the permanent sovereignty over natural resources. And that has had great implications for the universalization of the idea of the absoluteness or near absoluteness of private property. I'll come to that in a moment. The central problem with the UN's position and all of the instruments that it produced was that it provoked very little academic intellectual interest. Virtually nothing is done. You can't find anything that even begins to grapple with it. I did try to do something for the Academy on the human rights implications of the right to development, arguing that the initial version of it was excessively state-centric and therefore unappealing, but that's another story. Okay, well, what happened then was this. We come to this particular aspect of the theory, which was the resolution on permanent sovereignty, which had the implication of making vulnerable the investment, or the foreign investment in these economies. And what the new economic theory essentially stipulated in the Charter of Economic Rights and Duties of State, so that essentially drew the battle lines between the UN efforts to generate a new international economic theory and the theory that was adopted largely by the capital exporting countries. Now, the consequence of this was that it was obvious that these were two issues that were greatly contested. And the first contestation of significance took place before the Supreme Court of the United States in the 1960s. It's a case called, you can get it up there, third or fourth case, law and practice. The case was the Sabatino case, okay, of 1964. Castro's government had taken sugar and nationalized it by decree inside Cuba. The proceeds of the nationalized sugar were in a New York bank. The sugar owners filed what in law is called an in rem action. They seized the property. Property was put in the hands of a trustee, and they then proceeded to litigate who owned the proceeds. And that case ultimately went to the Supreme Court of the United States, very famous case. And the Supreme Court took the position that it was inappropriate for a domestic court to unilaterally reshape the standards for the taking of property. That was a contested matter of international law and should be managed by the international political process. Now, to do this, they invoked a doctrine called the Act of State doctrine. It's sort of derived from sovereignty, and to my knowledge, I haven't read a single economist who's ever heard of the doctrine. So maybe there is one, but I haven't heard about it. Okay? And what the doctrine essentially stipulates is that you can't challenge the taking of foreign property in another state in your own domestic courts. The domestic courts simply should not be able to test the lawfulness of a taking in another country. Well, this created a firestorm in the business community and politically. It resulted in 2 amendments to the U.S. Foreign Assistance Act. These are called the Hickenlooper Amendments. And fundamentally what the Hickenlooper Amendment said was there should be no barrier to a private operator suing on an in rem action in the courts in the United States. In other words, it said, no, the Supreme Court's wrong. Our courts have to adjudicate who owns the property and allocate the property according to the standards that it's adopted. The law that began to emerge in the context of foreign investment essentially meant that if a third world state wanted to attract foreign investment, it was forced to adopt the highest possible standards for the protection of private property, or you get no foreign investment. And those standards were also replicated in part by the World Bank and the IMF. So state practices in the capitalist world regarding the export of private property came with these extremely, almost absolute standards for the protection of private property law. The consequence of these developments was the development of something called the hot goods doctrine. Now, what this did was, it said basically that if property has been taken and the proceeds happen to be in another state, the claimants can seize the property with an in rem action and litigate who owns the property in that state. And this particular approach virtually brought the Chilean economy to its knees because they had nationalized copper. Wherever the copper interest appeared, they could file an in rem, take over the property, and then litigate its ownership. So those developments essentially really solidified from an international point of view a form for the protection of private property. It wasn't absolute, but it was the closest damn thing to being absolute. All right. Now, just quickly, one other element of this was the idea of NAFTA, and there you had the Canadian corporation which produced something called Methanex. Methanex was used in fuel, and it leaked into the water supply and contaminated the water. So dangerous that the California governor issued a decree saying we have to phase out this Methanex. Well, the company sued the California, state of California for something close to $1 billion for the losses it sustained in the governor declaring that we should phase out Methanex. And NAFTA has a rather odd method of dispute resolution. You have a closed system in which they determine these questions, you see. And the consequence was that the company lost but barely, but what it did do, it opened up a whole range of claims that maybe any time a state has regulations which has some effect on business and that business loses, it can claim property rights, you see. And so even though they lost the case, it remained an extremely open one in the context of, take this absolutist notion, and now you look at the system of capital and the regeneration of profits and so on, and what you got in the US capital markets is the creation of radically new forms of property exponentially. You don't really see this in history because property is a very conservative idea. But here you had a multitude of interests called derivatives, but at the back of the creation of these interests was the notion that once they're created, they really can't be challenged by the state. because they're private property, and private property is the absolute. So this virtually led to the meltdown in 2008. But these new forms of property are still there, and they do, indicate a massive shift of power to the private sector. And then I will just along with this creation of new property, you have a tremendous move by the law and economics crowd towards privatization and limitation, deregulation, limitations of the state's power. The less regulate, the better. More corporate tax cut, reduced taxes, and so on. And you can go on and on with this. But the central point is that now what neoliberal economics used was the legal architecture of legal experts to dismantle the state and to dismantle the state's power to regulate. That's essentially what it did. And a little later, we found the multinationals saying, we've got to get rid of the New Deal state. And the Federalist Society, the most conservative group backing this crowd, held a conference recently on how to get rid of the New Deal state. Now, the New Deal state is essentially the social democratic state, the one that you and I know. So what we're talking about here is the real effort to create a silent revolution to change the game. We don't know where it's going, but clearly it's there. And one of their leading theorists, a guy by the name of Epstein, took the position that any regulation that affects business and the value of business interests should provide that business interest with the right to sue the state for its losses. That means any regulation that has an effect on business can be subject to suit by business interests. So there's a fairly radical agenda here, but it's not one that's obvious to most people, and hardly any economists I know actually talk about it. Okay? So I then took these ideas and went into the new climate change economy and so forth. And I said that, look, if you're going to look at climate change, you can see these are radically opposed doctrines. And one of the issues that these people have done is, for climate change, they've now persuaded many states to say, well, climate change is a matter of national security. That looks like a very promising idea. But what the hell is it? What it is, it takes the thing out of the public domain, puts it into secrecy. The state doesn't have to do anything about it, and doesn't have to disclose that, in fact, it's not doing anything about it. You see? So that looks like it's a great deal. In fact, it's a shot in the back of the climate change advocates. And so I went through this, and then what emerged from this was the notion that at the back of the neoliberalism was a very powerful constituency, vigorously, give me 2 minutes, okay, advocating for this whole dismantling of the social democratic state. But we have no constituency which says, hey, maybe we've got something to secure and protect here. Maybe social democracy is an extremely important instrument of human freedom, you see. We don't quite have that. And so I found that Stiglitz has essentially made the same point, that neoliberalism has a powerful constituency, an army of lawyers behind it, to dismantle the state and to do its absolute show. There's a little bit more, but you can read my paper on that, and the importance of these constituencies who are the vigorous advocates for the destruction of the New Deal state. Thank you.